10 seconds, 5 seconds, start. That procedure will be compliance with the phrase ensuring whether there exists reasonable ground of the accused being guilty or not, but the question which needs to be answered is that what is the extent of jeopardizing the liberty of one person to ensure whether there exist reasonable grounds or not. The above mentioned lacuna firstly affects the quick disposal of bail, and later they are responsible for delay in sentencing. So, the conclusion that can be drawn from the above discussion is the fact that despite so many provisions in CRPC regarding bail or matters related with it, although drafted in good manner so as to ensure speedy justice due to some or other reasons as discussed above, code is not able to provide speedy justice. So, direction can be given in the form of writ of mandamus to the lower courts to consider bail petitions as fast as possible for them, but the point of caution that is to be noted is the fact that whenever such a direction is issued, then the High Court must take care that the speedily disposal must not cause injustice, because is accepted fact that if justice delayed is justice denied, then justice hurried is justice buried. As observed earlier, when the appellant appeared on 24th April 2002, he had moved an application that the copies of the plant and documents had not been supplied to him, and he was entering appearance as a matter of abundant caution. If a person who has taken such an abundant precautions to appear in the suit and has filed an application for supply of copies of the plant and documents, it is inconceivable that if the same were not given to him, he would not have made an application or would not have agitated the issue again in the court. From the impugned order, we find that learned single judge has observed that after 24th April 2002, the case was adjourned to 26th July 2002, where the appellant himself was present. On that date, it was not protested by the appellant that the documents and the plant had not been supplied. It is also to be noticed that on 27th January 2002, the application of summons for judgment was disposed of by the learned single judge in the presence of the counsel for the defendants. At that stage, also, the plea that the documents and the copy of plant were not supplied was not raised before the court. To our mind, The main purpose of the appellant is to delay the proceedings. To check such delaying tendencies, the CPC was amended. Considering all the facts and circumstances of the case, this court does not consider it a fit case for interference in the impugned order. The appeal is therefore dismissed. Trial court record be sent before. The averments made by the plaintiff are not founded on any cogent and reliable evidence. Non-production of two checks on record would by itself provide a defense to the defendant that the suit is not covered under Order 37 of the CPC. This itself is a matter of serious legal and factual controversy in the present case, which would require adjudication by the court. For the reasons afore recorded, IA 4539 of 97 is allowed. The applicants are granted unconditional leave to contest the suit on merits.